Hello everyone, my name is Mini Sethi. I hope you all are staying healthy. Today we are going to talk about Contract Labor Regulation and Abolition Act 1970. So what is contract labor? Contract labor is a person who is hired by contractor for specific time period for doing specific task, and this act came into force 10th February 1971, and main objective of this act to prevent exploitation of contract labor and introduce better conditions for them. And in order to achieve this objective, Contract Labor Act regulate employment of contract labor in certain establishments. In order to achieve this objective, Contract Labor Act regulate employment of contract labor in certain establishment and abolish contract labor in certain circumstances. Why abolish contract labor in certain circumstances? Because in some places management think contract labor are not part of their organization. That's why they do exploitation of contract labor. So in order to prevent exploitation of contract labor, government abolish contract labor in certain circumstances under this act. This act extends to whole India, and this act consists to total 35 sections. Firstly, we are going to talk about chapter 1. According to section 14A, this act applies to every establishment in which 20 or more workmen are employed as a contract labor. And according to section 14B, this act applies to every contractor who employed 20 or more workmen. But appropriate government can apply this act in any establishment by giving 2-month notice in official gazette. According to section 15A, this act will not apply on any establishment where they are doing intermittent or casual work. Intermittent or casual work means temporary work, short time period work, need based work, or we can say that irregular work. According to section 15A, this act will not apply on any establishment where they are doing intermittent or casual work. And according to section 15B, if any question arises whether this work is intermittent or not, then appropriate government will decide after consulting with central board or state board, and their decision will final. And work will not be called intermittent if it was performed for more than 120 days in preceding 12 months. In case of seasonal industry, work will not be called intermittent if it was performed for more than 60 days. Now we are going to talk about some important definitions according to this act. According to section 2A, appropriate government means, actually they relate appropriate government with Industrial Dispute Act 1947. मीन्स इंडस्ट्रियल डिस्प्यूट एक्ट 1947 में जिन इंडस्ट्रीज को आपकी सेंट्रल गवर्नमेंट कंट्रोल करती थी, सिमिलर इस एक्ट में उन्हीं इंडस्ट्रीज को आपकी सेंट्रल गवर्नमेंट ही कंट्रोल करेगी. एंड फॉर एनी अदर केसेस योर स्टेट गवर्नमेंट विल बी एप्रोप्रिएट गवर्नमेंट. According to section 2B, a workman will be called contract labor if he is hired by or through contractor with or without knowledge of principal employer. Means it is not essential when contractor is hiring, principal employer must know about it. अगर principal employer को नहीं भी पता कि hiring हो रही है, तब भी आपका labor क्या कहलाएगा? Contract labor. Now we are going to talk about definition of contractor. According to section 2C, contractor is a person who undertakes to produce given result for establishment other than supply of goods of article of manufacture. Means कॉन्ट्रैक्टर गुड्स की सप्लाई करने के अलावा एक एस्टेब्लिशमेंट के लिए एक अच्छा आउटकम भी प्रोड्यूस करे, गिवन रिजल्ट भी प्रोड्यूस करे. बट नाउ क्वेश्चन इज दैट हाउ कैन कॉन्ट्रैक्टर प्रोड्यूस गिवन रिजल्ट फॉर एस्टेब्लिशमेंट? बाय सप्लाइंग कॉन्ट्रैक्ट लेबर टू एस्टेब्लिशमेंट. So we can say that contractor is a person who undertake to produce given result for establishment other than supply of goods of article manufactured to such establishment through contract labor, or who supplies contract labor for any work of that establishment. Now we are going to talk about chapter 2, Chapter 2 talks about advisory board. And section 3 talk about central advisory board. Central government constitute a board. It will be called Central Advisory Contract Labor Board. This board consists of chairman appointed by central government, chief labor commissioner and some members. But number of these members cannot more than 17 but not less than 11. But what these members do? Government nominate these members to represent government, railway, coal industry, mine industry or a contractor or workman or any another case according to opinion of government. Chapter 2 and section 4 talk about state advisory board. State government constitute a board. It will be called State Advisory Contract Labor Board. This board consists chairman appointed by state government, labor commissioner, ex-officio or in his absence any officer nominated by state government and some member also. But number of these members cannot more than 11 but not less than 9. And state government will nominate these members to represent government, industry, contractor, workman or any other interest according to opinion of state government. Now we are going to talk about some important sections of chapter 3. Section 6 of chapter 3 talk about appointment of registering officers. Government by giving a notification in official gazette can appoint such persons being as a gazetted officer of government or as a government think he or she is suitable to be a registering officer for the purpose of this act. Plus government also define limits of registering officer and within these limit registering officer can use their power for making any decision under this act. Section 7. Section 7 talk about registration of certain establishment. Means how establishment can register themselves under this act. Government by giving notification in official gazette prescribe some time limit for establishment for class of establishment and within this prescribed limit every principal employer of establishment whom this act is apply make application to registering officer in prescribed manners for registration of their establishment. Section 10 of this act talk about prohibition of employment of contract labor. Appropriate government by giving notification in official gazette and after consulting with central board and state board can prohibit employment of contract labor in certain process, operations or other works in establishment. But before issuing such notification of prohibition, government will consider so many factors. For example, government can consider conditions of work, benefit provided to contract labor, or government can also consider whether process, operation or work is incidental or necessary for industry, trade or business. Plus, government can also consider whether such work is done through regular workers or contract workers in other similar establishment or not. Now we are going to do a chapter 4. Chapter 4 mainly talk about licensing of contractor. Section 11 appointment of licensing officer. Appropriate government by giving notification in official gazette can appoint such persons being gazetted officer of government or government think he or she suitable to be a licensing officer for the purpose of this act. Plus government also define limits of licensing officer and licensing officer can use his power of making decision within these limits only. Section 12 talk about licensing of contractors. Government by giving notification in official gazette can declare no contractor neither undertake nor execute any work of contract labor unless licensing officer issued license to him. Now we are going to talk about chapter 5. Chapter 5 mainly talk about welfare and health facilities for contract labor. Section 16 talk about canteen facilities for contract labor. Section 17 talk about restroom facilities for contract labor. Section 18 talk about other facilities for contract labor. For example, sufficient supply of drinking water, sufficient number of toilet and washing facilities, etc. And section 19 talk about first aid facilities for contract labor. Section 20 talk about liability of principal employer in certain cases. Prime responsibility belong to contractor to providing all facilities under section 16, 17, 18 and 19. But in case contractor fail to provide all these facility, then principal employer will liable for this. And section 21 provide responsibility of payment of wages. Contractor will be responsible to make payment to contract labor in prescribed time period. But if contractor is not able to make payment within prescribed time period, then principal employer will make payment to contract workers within prescribed time period. Now we are going to talk about chapter 6. Chapter 6 mainly talk about penalties and procedure. There is one inspector in this act who basically do inquiries related to any issue under this act. And we will study about inspector in next chapter, but this concept mainly related to inspector. Section 22 obstruction. Whoever create problem for inspector for performing his duty or refuse or willingly neglect for giving any facility which inspector need for making inspection, examination, inquiry, investigation shall be punishable, and punishment will be imprisonment which may extend to 3 months or fine which may extend to 500 rupees or both. Section 23. Contravention of provision regarding employment of contract labor. Whoever contravene to any provision of this act, any rule of this act which are made for prohibition, restriction and regulation of this act, or contravene any condition of license granted under this act shall be punishable, and punishment will be imprisonment which may extend to 3 months or fine which may extend to 1000 rupees or both. But in case of continuous contravention, additional fine which may extend to 100 rupees for every day. Now we are going to talk about chapter 7 and section 28, inspecting staff. Appropriate government by giving notification in official gazette can appoint such person as government think he or she is suitable to become an inspector for the purpose of this act, and government also define local limits of inspector, and inspector can use his power within these local limits, and also define some rules. For example, inspector can enter in any premises at reasonable hours and can examine any register, record or notice which required to kept under this act. Now we are going to section 29. Section 29 talk about a registered and a record to be maintained. Every principal employer and contractor shall be maintained registered and record, in which include information about contract labor employed. For example, nature of work they performed, wage rate they paid, and other information as prescribed by government. Section 31. Power to exempt in special cases. Appropriate government by giving notification in official gazette can exempt some establishment for following all rules and regulation under Contract Labor Act for time being, or we can say the for short time period. Or we can say that appropriate government by giving notification official gazette can declare rules of Contract Labor Act shall not apply to any establishment or class of establishment or any class of contractor. So this is all about Contract Labor Act. I think you got it, and thank you so much for watching this video. Bye, take care.